Moving now into compliance. In general, managers want to tailor their compliance programs to the specific firm activities. It's very important that managers do what they say that they're going to do in their compliance program, and therefore that is going to be a very important part of ultimately implementing a compliance program. One of the requirements when implementing a compliance program is to specifically name a chief compliance officer. This person will actually be named on the Form ADV and will be in charge of liaising between the manager and the state or SEC during an examination process. During the compliance program setup, one of the main deliverables is going to be a compliance manual and code of ethics. The compliance manual is generally going to include a discussion about the manager's fiduciary duty and insider trading policy, a discussion of the personal trading policies, the privacy policy for clients and investors, and the soft dollar programs that the manager is engaged in. There's also going to be the books and records which need to be kept as part of the firm's compliance program. On the record side, there's client information and fund information that needs to be kept, firm financials, information on employees, and advertising that the manager does. On the retention side, these records may be maintained electronically, but they must be available for immediate and complete access. They're going to be maintained for 5 years, the first 2 in an easily accessible place. And if a manager withdraws, then the manager needs to preserve his records for 3 years after the withdrawal. There are some common deficiencies for managers, and these were recently outlined in a GAO report. These include registration issues, books and records issues, unethical practices, and supervisory and compliance issues. For fund managers have specific issues which tend to be important for them. These include valuation, cross-trading, preferential treatment of investors or clients. All of these issues are going to be dealt with in the compliance manual and established procedures with respect to the compliance program. So these are all issues that can be dealt with, and so a manager who has these sorts of issues really needs to discuss them with the lawyer or the compliance person. So now we're moving into post-registration compliance. This includes a discussion about the compliance program, updating the Form ADV, and regulatory examinations. For the compliance program, the lawyer or compliance person will be helping the manager to develop the program, which will include email archiving, trade reviews, trade preclearance, best execution analysis, soft dollar review, IPO allocations, the various forms that need to be filed, 13Ds and Gs, 13F, new Form 13H, that's the large trader reporting form, Form PF if it's applicable to the manager, and then blue sky filings. The compliance program should also address certain regulatory hot button issues, including social media, expert networks, and insider trading, which we all know has been a very big issue at both the SEC level and at the state level, pay-to-play issues, and related broker-dealer issues. As part of the compliance program, the Form ADV also needs to be periodically updated. First of all, it needs to be updated annually within 90 days of the end of the manager's fiscal year. There are other than annual amendments as well if there are changes in certain information. And then there is a registration renewal generally that information will be coming out, will come out via email either in late October or early November. Managers may also be subject to regulatory examination with either the SEC or the State Securities Division. The timelines for examination are always changing and really depend on budgets at both the SEC level and state level. In general, at the SEC level, a fund manager might be examined every 5 years. At the state level, maybe between 3 and 7 years. Again, a lot goes into that determination, and if managers have a larger amount of assets, then that timeline might be lower. Also, some states have an initial examination, a kind of getting to know you examination with managers who have recently been registered. What some firms will do is they will go through a mock audit. And there are two reasons to go through a mock audit. Number one is obviously to prepare for a regulatory examination. So in these instances, a manager would get a notice from the SEC or State Securities Division and then have a mock audit with a compliance firm or a law firm in order to make sure that the manager understands how the examination is going to work, and so that the manager is appropriately prepared for the regulatory examination. A second reason for mock audits is simply to stay up to date on the best compliance practices for the manager. These law firms and compliance personnel are going in and out and seeing a lot of managers' compliance programs and should be up to date on the latest and greatest best practices for compliance. And finally, that brings us to other issues. The first issue is outsourced compliance. We've seen a lot of managers move towards outsourcing their compliance, and that can either be done on an ongoing monthly basis, or these outsourced compliance companies can actually take on the full compliance obligations and be named the outsourced CCO. These are good programs, and a lot of managers are deciding to move in this direction just because they don't have the time necessary to appropriately devote to having a full-time compliance program in place. There are other manager-specific issues which may apply to certain groups depending on the exact nature of the business activities of the manager. This includes managers with bifurcated management structures and other managers who have specific issues. If there are specific issues, those managers should reach out to their law firm or compliance firm and discuss those issues with the group that's helping them through the registration process. Now, this program did not discuss futures trading at all. It only discussed securities trading. If a manager is doing futures trading, the manager should note that they are subject to CFTC oversight and not SEC oversight. And so that may just add another different registration requirement. If a manager is trading futures, please feel free to contact us to discuss the futures registration regime. It is different than the SEC. So if you're doing that, please feel free to contact us as well. And then finally, further rulemaking is likely coming down the pike. The SEC and the state securities commissions have not completely finalized all of their rules, and some of these some of the new regulations are being developed right now. So please stay in contact with us if you'd like more information on further rulemaking. My name is Bart Mallon again. I can be reached at 415-868-5345 or by email. Please also feel free to visit our legal blog, hedgefundlawblog.com. We would be happy to answer any questions that you might have, or if you have comments on this presentation, we would love to hear them as well. We hope that you found this presentation informative, and again, be happy to answer any questions that you might have. Thank you very much.